Hello, everyone, and welcome to the Privacy Rules webinar series. My name is Lauren Toussaint, Executive Director of Privacy Rules. I am joined today by my colleague, Alessandro Damatia.
Hello, everyone.
And the two of us are pleased to present this series and our experts. Today, we have brought together 4 expert attorneys to discuss data transfers and the laws governing the transfer of personal data in their respective jurisdictions. First, we will hear from Gabriel Avigdor of DataLex in Switzerland, who will give us a brief overview of the GDPR and then the Swiss law. Next, we will hear from Stanislav Rumyantsev of Gorodovsky Partners in Russia, who will take us through Russian regulation governing data transfers. Then we will hear from Lucia Fernandez of Gonzalez Cavillo in Mexico. And finally, Akira Matsuda of Awadagodo in Japan. We will end the webinar with a brief discussion of practical challenges and new developments in data transfers. We thank you again for tuning in, and without further ado, I hand it over to Gabriel Avigdor to give us a brief introduction on the GDPR and data transfers.
Okay, so thank you very much for inviting me for this webinar. Talking about the specific topic of cross-border data transfer under the GDPR, the general concept, it's a balance. It's a balance between having the appropriate safeguards to protect the personal data with adequate level of protection, either because it's recognized by the EU Commission or because you put in place some mechanism. On the other hand, the aim is not to have unjustified obstacles to those transfer, to allow the market to be still possible. Essentially, on data transfer, between the directive and the GDPR, the concept remains the same. However, we can see under the Article 44 to 49 some clarification and some additional mechanism. So data transfer under GDPR, what are the conditions? Under the GDPR, the transfer outside the EEA, the European Economic Area, are still regulated and limited. You have derogation, as mentioned before, to allow those cross-border data transfer. Additionally, you don't need to notify the standard contractual clauses, which was the fact under the directive. You can use BCR, binding corporate rules, to have a mechanism for intra-group data transfer and implement this framework internally in your organization. Also with the GDPR, which is something that was discussed extensively among the globe, is the enforcement. Fines could be pretty high, and you have under Article 23, the maximum fine of 20 million or 4% of the global turnover if there is a breach of this obligation to transfer personal data with appropriate mechanism. Also, you have the privacy shield and the standard contractual clauses that you can use, but they are questioned again by individuals.
Thank you very much, Gabriel, for your introduction on how GDPR works and how data transfer happens for the European regulation, actually. Now we can see an overview on how it works in the country that we are going to benchmark today. We are trying to cover basically different parts of the world. Now I would like to ask you if you can explain us how it works with data transfer and which is the relation of the data transfer system you have in your country with the European data transfer system. We will go on with Gabriel that will start with Switzerland, and then we will move on Russia, Mexico, and Japan for every topic regarding the data transfer.
Data protection in Switzerland is very much influenced by human rights, especially the European framework. Switzerland is part of the Convention 108 and its protocol, which makes this convention binding, the European Convention of Human Rights, and is part of the Schengen acquis. Despite the fact that we are located in the same region as Europe, we are not an EU country, and no EU or ruling applies to Switzerland. However, we have the adequacy decision, which makes the cross-border data transfer possible within this region between Switzerland and all EU countries. As a general rule, the transfer of data is prohibited unless there is no danger to the data subject. And you have a list of approved countries where you can transfer data in this area, or you can rely on derogations to transfer data to non-adequate countries. So if we have a look at the Swiss privacy framework, we have the Federal Constitution, a Data Protection Act and its ordinance and sectoral laws, as well as 26 cantonal laws. The Swiss Federal Constitution provides a general right to privacy, including protection against unlawful processing of personal data, and the Data Protection Act is a comprehensive act with the ordinance which provides more details on, for example, how to implement security measures, appoint a data protection officer, or to provide access rights to individuals. Also, it's worth noting that we still have the adequacy decision, and we expect to maintain this adequacy decision until we pass our new law, and the Swiss Federal Commissioner can only issue non-binding recommendation and cannot enforce those recommendations. So, for example, the Commissioner cannot issue direct administrative fines, such as under the GDPR. So if an individual would like to issue a complaint and make an enforceable decision, this person needs to go in front of an ordinary court, civil or criminal. So if we go into the details of data transfer under Swiss laws, there is a general prohibition to transfer personal data out of Switzerland. However, you can transfer personal data out of Switzerland when there is an exception or a derogation. Those exceptions can be to transfer data with the adequacy decision to country where there is an adequate level of protection, or if you use derogation as detailed in this slide. So you can use appropriate safeguards, you can use the consent as a legal basis for transferring personal data. You can also have access to a medical record when there is a vital interest of the data subject. You may also use a contract to transfer personal data where this data relates to the services that you provide to the other party, or use data that are publicly accessible where there is no objection or a public interest, or to defend legal claims and transfer data within your company. Now in this chart you see in the first column that you can transfer data to approved countries, and the Federal Commissioner maintains such a wide list of countries to which you can transfer data from Switzerland to those countries. This is also possible for intra-group data transfer. In the second column you see that there is a general prohibition to transfer data unless you conclude a contract, you use derogations as a legal basis for the processing, use other mechanisms such as template contracts provided by the Commissioner or the standard contractual clauses, and you need to inform the Commissioner for transfer of data to non-safe countries or for data transfer agreement. Finally, you have other restrictions, such as in the healthcare sector with the medical secrecy, and the banking sector with the banking secrecy, where normally there's a prohibition to transfer data outside Switzerland because you cannot ensure the same level of secrecy. There are some exceptions to those, but it's generally prohibited. The same applies to outsourcing, where you would need a legal basis or a contract and to ensure the same level of secrecy to transfer data outside Switzerland. Switzerland is one of those countries which requires the data controller to declare the files to the Data Protection Authority. You need to declare what safeguards you have put in place and what security measures and protection measures you have implemented. Also, you need to declare and notify the Commissioner as soon as possible, but before the processing and the transfer of personal data to outside Switzerland. And you need to explain to the Commissioner why you think that the recipients ensure the same level of protection. So if your business do not want to declare the files to the Commissioner, you can use contractual clauses. You can appoint an independent privacy officer internally who is responsible for the records of processing and to deal and counsel the company about data protection. These are exceptions where there is no obligation to declare data transfer to the commissioner. And as a last point, data subject needs to be informed about those transfer, and this can be performed through information which can be provided through a privacy notice to comply with the obligation of transparency. And for sensitive data, this requires informed or explicit consent. So if you plan to do business with Switzerland and to transfer data between your country, whether it is an approved country or a country that is a third country, with Switzerland, you can go on the website of the Federal Commissioner and you can find some resources in English, including whitelist, guidances, opinions, and templates.
Thank you very much, Gabriel. So now we move on how it works in Russia. We have today Stanislav Rumyantsev from Gorodisky and Partner, that is our law firm in Russia. Thank you, Stanislav.
Hello, I'm glad to be here. And now a couple of words about Russia. If a country does not support an adequate level of data protection from the perspective of Russian law, then certain formalities must be fulfilled. First of all, it is necessary to have good grounds for sending personal data to such countries. For example, it may be necessary to receive a data subject's consent in writing. It is possible to send data in line with a contract concluded with the data subject, for example, to provide services or products on the territory of such country. There are also some other grounds for sending personal data to countries not supporting an adequate level of data protection. Please take into account that Russian law does not provide for standard contractual clauses, binding corporate rules, or any other similar instruments which are commonly used in the European Union. There are three types of documents which should be used for cross-border transfers from the territory of Russia. First of all countries to which personal data is transferred must be mentioned in the data protection notice submitted to the Russian Data Protection Authority. Almost all companies in Russia must send this notice and specify all their data processing operations. The second type of documents is the agreement between the data exporter and the data importer. First of all, the data can be sent on the ground of the data processing agreement. This concept is very similar to the data processing agreement under GDPR. Another type of agreement is the confidentiality agreement. This document can be used if personal data is sent to the data importer for independent processing, meaning that the data importer located outside of Russia will not act as a processor of the data exporter. The third type of documents is the data subject's consent or in agreement with the data subject. If the data is sent to a country supporting an adequate level of data protection, then it will be necessary to receive a consent to the disclosure of data to a third party located in such country. If the data is sent to a country that does not support an adequate level of protection, then it will be necessary to have two consents. The first one to the data disclosure and the second one to sending data to such country. Please take into account that the concept of legitimate interests is not well developed under Russian law, and that's why the preferable option is to ground your data transfers on the consents or agreements with the data subject. Under Russian law, it is impossible to collect personal data from Russian citizens and immediately send it for processing outside the territory of Russia. All companies must create local databases containing personal data of Russian citizens, and then it will be possible to copy all locally stored data to some other place outside of Russia and then process it there. This requirement is called personal data localization requirement.
Thank you, Stanislav. We are now moving to Mexico. We have Lucia Fernandez, and we thank her to come here to explain how data protection legislation works in Mexico.
Thank you. I would like to start the presentation with 4 basic points of data protection in Mexico. First, the right to privacy and personal data protection is contemplated by the Mexican Constitution. Second, the most relevant legislation as applicable to private parties is the federal law on the protection of personal data held by private parties, its regulations, and the privacy notice guidelines. It is important to note that other laws regulate the processing of personal data by governmental entities. Third, the Mexican Authority in Data Protection is the National Institute for Transparency, Access to Information, and Personal Data Protection, known as INAI. Finally, Mexico is not considered as having an adequate level of data protection by the European Commission. Nevertheless, the Convention 108 of the Council of Europe and its additional protocol came into effect in Mexico as of October 1st, 2018. Before we start with the main topic, it is important to talk about consent, since under Mexican law, any processing of personal data requires the consent of the data owner, which is the term used in Mexican laws to refer to the data subject. Unlike other legislations, we have 3 types of consent in Mexico. The first type of consent is tacit consent, which is a general rule and is obtained when the controller makes available or presents to the data owner the privacy notice and he or she does not object. The second type of consent is express consent, which is required when the controller processes financial data. Express consent needs to be conveyed by the data owner verbally in writing, by electronic means, or by any other technology. The third type of consent is express and written consent, which is required when the controller processes sensitive data. Express and written consent needs to be conveyed by the data owner through his or her wet ink or electronic signature. As you can see in the presentation, there are exceptions that allow controllers to process personal data without consent of the data owner. These exceptions should be considered when processing personal data in Mexico. Going into the main topic, cross-border data transfers under Mexican law, we need to start with the definition of transfer. Under our privacy laws, a transfer is a communication of personal data between a controller and a third party. This concept is different from data transmissions, which are communications of personal data carried out between controllers and processors, and no consent of the data owner is required. Meanwhile, data transfers need to 1. Be consented by the data owner, and 2. Comply with certain formalization requirements set forth in the law. Regarding the first requisite, the personal data laws state that any potential transfer of personal data must be informed to the data owner through the privacy notice, and the data owner must provide its consent thereto. The type of consent needed, that is tacit, express, or express and written consent, depends on the type of personal data that will be transferred. There are cases in which transfers may be carried out without consent of the data owners, some of which you may see in the presentation. Regarding the second requisite, cross-border data transfers need to be formalized through agreements or contraction clauses executed between controller and the third party, which need to evidence 1. That the third party assumes the same obligations that the controller has in connection with the personal data processing. 2. The conditions under which the data owner consented the personal data processing. And 3rd and last, that the controller provided to the third party the privacy notices consented by the applicable data owners. Any third party that receives personal data abroad needs to keep in mind that it is not considered a controller under Mexican data protection legislation, and it is not subject to such laws. And finally, it may only process the applicable personal data for the purposes included in the privacy notice it received from the controller.
Thank you very much, Lucia, for your introduction. And now we can move to our 4th member, last but not least, that is Akira Matsuda. Thank you, Akira, to be here.
Thank you very much. Before going into the details of the cross-border transfer restriction of personal data under Japanese law, I would like to touch on the latest news, which is the reciprocal adequacy decision between EU and Japan, which became effective on January 23rd this year. According to this reciprocal adequacy decision, EU and Japan consist the world's largest free trade zone of personal data. Thanks to this reciprocal adequacy decision, transfer restriction from EU to Japan or from Japan to EU are basically lifted off. However, as in the third bullet point, Japan had taken several steps to fill in the gap between GDPR and Japanese legislation APPI in order to cope with the concerns raised by EDPB and EU Commission. I will explain in detail these safeguards later. This slide shows the outcome of the reciprocal adequacy decisions. As I explained before, transfer from EU to Japan can be made freely, but in Japan, entities must comply with supplemental rules enacted by the Japanese government. On the other hand, such supplemental rules are not applicable for data which are transferred from Japan to EU based on the adequacy decision. I will explain details of these supplemental rules in Japan in later slides. In this slide, I will explain the brief overview of the cross-border transfer restriction of personal data under Japanese law. In principle, specific consent from the data holder is required in order to export personal data from Japan to outside Japan. If such specific consent of the data holder is not obtained, the entities in Japan must comply with either of these three exemptions. The first exemption is what is called as a whitelist exemption. At this time, only EU is designated as such whitelist countries, so this exemption can only be used for data exports to EU. The second exemption is either enter into contract or install the internal corporate rules among the same group entities. This exemption is practically most widely used because the first exemption that I mentioned and the next exemption can be only used in the limited circumstances. The third exemption is the Apex CBPR framework, where administrative agent, which is recognized as this framework, certifies the data importer, and data transfer to such data importer can be made freely. As to exemption 2, it is most common for Japanese companies to enter into data transfer agreement with data importer located in the foreign countries in order to comply with this exemption requirement. As I explained before, data importers in Japan, which imports personal data from EU based on adequacy decision, must comply with additional safeguards requirement in Japan, which is to fill in the gap between GDPR and the Japanese law. There are 5 items which put stricter regulation than the original Japanese law. The first is expansion of sensitive personal data. Sensitive personal data under the GDPR is wider than Japanese law, such as information on labor union, and this is to conform the definition to the GDPR. The second is the expansion of personal data, which gives access and correction rights by the data subjects. Under the Japanese law, as regards personal data deleted within 6 months, companies need not provide access and correction rights to the data holder, but such limitation is lifted off for data imported from the EU. The third is limitation on the purpose of use as to original purpose of use under the GDPR. The fourth limits the onward cross-border transfer of the EU-originated personal data, which is transferred from EU to Japan based on adequacy decision. In this case, Apex CBPR framework exemption cannot be used. The fifth is the deletion of the anonymization methods, which means for the anonymized data in Japan, decryption key can be kept with certain security measures, but for those information transferred from EU to Japan, such decryption key must be deleted. As a concluding remarks, I would like to touch on 2 points. The first is what entities in Japan should do when they import EEA personal data from EU and handle them in Japan. Please see the red chart number 1. The data importer in Japan must reflect additional safeguards requirements, internal rules, and privacy policy when they are importing personal data based on adequacy decision. Number 2. If those entities are onward transfer personal data from Japan to outside Japan, with regards to the EEA personal data, such entities must enter into SCC arrangements or enter into data transfer agreement with the data importer, which is located outside Japan. Second, please see the gray chart below. Here, I would like to summarize the cross-border transfer restriction under Japanese law. So as a basic, Japanese entities which are going to transfer personal data from Japan to outside Japan must obtain explicit consent from the data subjects. If such explicit consents are not obtained, the companies must enter into data transfer agreement with the data importer or install binding internal corporate rules among the corporate groups, or if the transfer is based upon the APEC CBPM framework, such transfer will be legal. If these requirements are not met, Japanese entities cannot export data to countries outside Japan, and such cross-border transfer are illegal under Japanese law.
Thank you, Akira, for that wonderful presentation. As discussed, we will now turn to discuss some of the practical challenges that each of these experts deal with in their daily practice. I will first turn to Lucia Fernandez for her perspective on that. Lucia, if you'd like to go ahead and respond to some of the practical challenges that your clients and you address every day.
The most challenging issue here is the content of the data transfer agreement. The INAI, the authority in connection to data protection in Mexico, just has issued very little information in connection to the content that this agreement should have. There's only one guide, which is non-binding, and it states very briefly just certain points that the agreement should have and issues to consider when transferring information, and it does not give much more information than the one set forth in the law. So it's very challenging to know the real content and the extent of the clauses and how stringent those clauses should be in connection to the transfer of information. So this has been a real challenge, and it's a challenge in general when handling the INAI. They do not have a lot of information in connection to a lot of issues. So there's a lot of uncertainty in connection to how to handle or how to evidence various issues in connection to data protection in Mexico.
Now, you said that it functioned on the basis of consent. So do you find that are these contracts followed even once they are in place?
So they are followed, particularly when you transfer information abroad. I think people abroad, particularly in the US or Europe, are very concerned about fulfilling laws and making sure they're doing it pursuant to law. The issue here is that you know you're gonna have certain issues, for example, confidentiality. Those are gonna be fulfilled by the parties. There's no issue about that. But in connection, for example, to security measures, it's actually strange. In Mexico, we have more requirements in connection to our security systems, the security systems that need to be complied by data controller, than in other countries, which just give you a more general direction of how to do things. In Mexico, it's very specific. We're a very formalistic country. So those types of issues will be a challenge when you transfer information, because it will be hard to actually know that they will have all those requirements that are set forth in a very formalistic law, which is different from Europe, which is you have legal interest, as a legal basis of processing information. We don't have it here. So I think that's an issue to understand. Every time people come to Mexico, it's hard to let them know that it's not enough to comply with their laws abroad, or even with GDPR, which is now the world standard. We have our own standard, and you need to fulfill it when you're doing business in Mexico. So that's challenging to transmit to our clients.
And Stanislav, what about you? What practical challenges do you face in Russia in your practice every day?
Well, a practical challenge, at least for international companies, is that if they want to send personal data from the EU to Russia and vice versa, it will be necessary to enter into a data processing agreement under GDPR and also to conclude a data processing agreement under Russian law. The scope and content of these agreements are different. According to Russian law, there should be several mandatory clauses, and there are several mandatory clauses under GDPR, and they are not identical. And of course, in many cases, our clients want to enter into only one agreement covering both issues, both GDPR and both Russian law. And that's a bit problematic. In fact, that's really difficult to comply with both systems in one document, and this is always a challenge. In my opinion, the best solution is to conclude two agreements with similar scope, but with different clauses. So their concept, the idea should be the same, but the wording should be different. One agreement will work under GDPR, and another one will regulate the same relations, but it will be done under Russian law for the perspective of the compliance with the Russian legal requirements. And that's why the Russian agreement can be prepared in Russian language, and the GDPR agreement can be prepared in English or in some other European language.
Akira, with the recent adequacy decision, the European ministers have said that it's created one of the largest, safest zones for the transfer of data between EU and Japan. Has this greatly reduced problems or practical challenges in the Japanese jurisdiction and in your practice, or what kind of challenges do you continue to face?
I am always trying to advise my clients that this adequacy decisions does not mean freedom. It's called a free trade zone of information, but this means that if a Japanese corporations or entity based in Japan is in breach of supplemental rules or Japanese regulation in any way, this could be treated as a breach of GDPR, either in the processing requirements or the transfer requirements. So companies must make sure that they fully comply with Japanese laws or supplemental rules when they handle EU personal data. And this is not typically not recognized by the companies. They just think that all the regulations are lifted off and they can freely trade information. But this conception is very wrong because of the inappropriate treatment of personal data in Japan. This could be a large issue in Japan. So I have to emphasize that it's very important to comply with Japanese law and the supplemental rules.
And finally, Gabriel, to you, what challenges remain in Switzerland for transfers of data in and out of Switzerland?
I think the main question for us in Switzerland is, are we going to maintain our adequacy decision? Because to align on the GDPR, it's still not passed, and there is a risk. I think it's very low, but I think there is still a risk that we may not maintain the adequacy decision. So it would mean cross-border transfer would be a huge challenge, because you would go to the situation where you had adequacy, where then you do not have any automatic safeguard in place. I mean, in place to transfer data automatically without any proper safeguard. So it would mean that all businesses will have to put in place contracts or standard contract clauses. It's going to be a huge mess. However, it is pretty unlikely that Switzerland will lose this one. The draft bill is going to be very aligned on the GDPR. It's just a matter of urgency, which sometimes it's not a priority in terms of political aspects. So we just wait for this to be passed as soon as possible. On the other hand, I think one of the challenge is to ensure that all the companies understand that they need to take care of data transfer, because most of the time, because in Switzerland you have more than 99.8% of entities of companies that are SMEs, so small to mid-sized companies. They are not really aware of the requirements, so they may transfer data in a way that is not compliant. So I think one of the main challenge in Switzerland is awareness and trying to explain what are the requirements. Even though the law is pretty mature and it's very well structured and we have a comprehensive framework, it's still about awareness and giving to the companies and individual information about what to do and how to do it properly. So I will summarize this in that way.
Yeah.
So just in connection to, it's very important just to mention new developments in Mexico. The new development, which is the most important one right now, is the treaty between the United States, Mexico, and Canada, which was signed in November. It's not yet ratified. It's going to take a while to get ratified. People are talking about 2020, but it depends on the whole processes that the countries need to go to ratify it. And Chapter 19 is pretty important for personal data, which relates to digital trade. And the first one and the most
And you're referring to the NAFTA?
No, it's called now USMCA, which is NAFTA 2.
Yeah.
But Trump doesn't say it's NAFTA 2, so it's US. And the digital trade chapter is very, very important for personal data. Particularly, first, it now says that all the parties need to have a legal framework taking into account principles and guidelines provided by international bodies. Mexico and Canada already have comprehensive laws, which probably do not need to be greatly modified, but it's going to be interesting how the U.S. is going to fulfill that part of the convention.
Yes.
The second one is that it prohibits cross-border transfer of information. You need to ensure that data can be transferred cross-border, but they did leave a carve-out, which I think is very important. You can include such measures to restrict international transfer when it is necessary to achieve a legitimate interest, public policy objective, which we're gonna. I mean, there's criteria in the convention to measure if it's considered legitimate or not. But it's going to be interesting to see how the parties are going to regulate that part of the carve-out. One that has been really relevant, particularly in Canada, because they do have those types of laws. I think it was in Quebec or Montreal. It bans data localization laws. That's not an issue for Mexico because our law does not require that the information of Mexican people needs to be on Mexican soil, but Canada, some of parts of Canada do. So I think it's going to be interesting how the parties are going to make sure that this is going to be implemented on each of the countries. And I'm particularly curious about the US because you consider that you have sectoral laws.
Yeah.
I mean, they can keep the sectoral laws, but the principles and guidelines, I'm not that sure if it's gonna be an issue or not to adopt them or to adopt new ones.
Yeah, the requirement to have a role, right?
I mean, you have federal ones, but they're for specific sectors. I don't know if you need for additional sectors or you need to modify those laws. It's going to be very, very interesting to see how it's going to need to be adapted.
Yes. And
Stanislav, what about you? Are there any new developments in Russia and Russian law?
The most important development is that Russia joined the additional protocol to the European Convention on Data Protection,
Yes.
ETS 108, the
Yes.
number of the convention.
Yes.
Yeah, the amendments have not entered into force yet, but they will in the coming years. And Russia was among the first signatories to the amendments. And that's why, according to the Russian Data Protection Authority, now they're developing new legislation to meet all new requirements of the convention. That's why we are expecting some new legislation and new court practice here in Russia already this year. There is no drafts or any clear proposals by now, but we know that the Data Protection Authority is working on them, and that's why they should be ready soon.
Great.
I see that Akira looks like to say something.
Maybe this is not strictly very relevant to the latest developments, but what I want to say about the Japanese legislation for a multinational company is that our legislation was wholly amended 2 years ago, and sometimes this fact is not informed or well known among foreign-based multinational companies. And I'm very often asked the question, we comply with GDPR, and we understand GDPR imposes a stricter restriction than Japan, so we do not need to comply with Japanese law. This is correct in some sense, but incorrect in other sense, because Japanese legislation imposes some unique requirements different from the GDPR, and this has nothing to do with the adequacy decision. So, and I still see so many foreign-based companies has not complied with the Japanese regulation. So it's very important that as a compliance checklist, those companies which have a subsidiary or a branch in Japan make sure that they comply with the Japanese regulation, which was amended 2 years ago.
And in terms of new developments, to you, Akira, with the new adequacy decision, is it fully implemented, or will there be further changes to the law? And if so, what is the plan moving forward in Japan?
It is discussed in Japan that in order to maintain the adequacy decision made by the EU Commission,
Yes.
Within 1 or 2 years, the authority will amend the law to strengthen, as I explained before, supplemental rules are only rules, but they could incorporate those additional safeguards into the level of law. And some other stricter regulations to more conform to the GDPR, but this is still a preliminary stage of debate, and we have to watch carefully what will come out in the next 1 or 2 years.
Great.
We would like to thank all of our experts again today. We hope you've enjoyed tuning in to this Privacy Rules webinar. There'll be more to come, so please check us out soon at privacyrules.com. Thank you very much.